to talk about what SEPs are, or SEPs, Standard Essential Patents. Mr. Cohen, are these government creations, or were these created by private industry, this nomenclature and this grouping of patents?
They're predominantly created by private standards development organizations, which have private sector participants, although there are government standards, particularly in China, but also in the US.
Okay, thank you very much. Dr. Copan, you joined several former administration officials, former I say, to send a 2023 letter to the European Commission opposing the EU's draft of SEP regulation that would cap royalties for licenses of standard essential patents and create separate centralized proceedings at the EU IP office. Do you continue to have concerns about the efforts of foreign competitors to regulate our IP?
I do, Congressman. Those concerns that I also included in my oral testimony are with respect to the overreach of governments to regulate free trade and fair commerce and standard essential patents. And I stand by that joint letter.
Aren't a lot of the patents created by U.S. entities? And isn't it sort of insane to let countries, not just China, I mean, we're here ostensibly about China, but the EU is talking about doing the same thing. Because these patents are so important to things like national defense or our own competitiveness in the world economy, isn't it kind of crazy to go along with this scheme in the European Union that would let them effectively nationalize our IP by setting the rate that could be charged globally for it?
It is a huge concern. The United States' sovereignty over its intellectual property rights and the value that U.S. innovators create in global markets is something that needs to be part of a free market economy. And we know that sophisticated companies, developers, and implementers of technology have the guidance in fair, reasonable royalties that are non-discriminatory and enabling the practice of commerce across borders without government interference.
Well, I've heard some arguments that SEP, standard essential patents, are so important that you shouldn't be able to get injunctive relief, that the owners of the IP shouldn't be able to get injunctive relief. Do you agree with that argument?
No, sir. Intellectual properties that are standard essential patents are patents and deserve the same protections as the intellectual property rights of innovators in the United States, and indeed protections in jurisdictions elsewhere where intellectual property parallel protections exist.
Let me ask you, you mentioned some legislation that you were a fan of. What could we do in our own country with our own IP laws to improve American competitiveness and improve our national security?
Definitely the improvement of clarity with regard to patentable subject matter is an important feature. Creating greater certainty in our courts of the basis on which decisions are made, in particular with respect to standard essential patents. And I also believe it's very, very important for the United States to continue to lead by example, as I had indicated in my remarks, that the United States has a fair and reasoned process for adjudicating issues in our courts that enable rights holders around the world to trust the U.S. judicial system and that they know that the United States sets the highest standard globally for fairness in intellectual property matters.
Mr. Cohen, I want to give you a chance to answer the same question. What do you think we could do here to, with our own IP laws, to improve the signal that we send to other countries that we're the best country for developing IP in?
Well, I certainly agree with Dr. Copen's perspective on strengthening the domestic legal system in terms of patentable subject matter, availability of injunctive relief. There's another aspect in terms of the competition globally for jurisdiction over FRAND disputes and parallel disputes that arise. So we could find that even if we have the best system in the world, China can fast track its litigation so that case will be resolved on appeal from beginning to appeal within 9 months, according to the Chinese civil procedure law. At that 9-month stage, we haven't even finished discovery in a U.S. district court. So having expedited procedures, perhaps specialized tribunals, although I'm not a big fan of that, but at least slimming things down so that people can get a quick relief, and having better assessment of the foreign competitive challenges. I'd like to see our Solicitor General from time to time appear in SEP cases to say whether a particular jurisdiction is fair or the potential disadvantages. I know one case in California where the judge was quite clear that by the time he renders a judgment in that case, China will already have exhausted its appeal. We have to make our system more attractive in the global competition for litigation on fair matters.
Thank you both very much. I agree with you on injunctive relief here domestically. I yield back to the chairman.
Briefly, Mr. Baker, did you have something else to add? You took copious notes.
Yes, if you don't use injunctions correctly, FRAND is absolutely meaningless. Injunctions were used because of a characterization called holdout, where a company like U-Blocks might not take a license. Unfortunately, if you look at especially foreign injunctions in Germany and over in China, what you'll find is there's no FRAND analysis. It's the fact that, all right, here's something, we're going to assume it's FRAND. If you don't take that license, we will issue an injunction. You can throw FRAND out the window with that. Also with standard essential patents, the problem that you come up with is it used to mean, and I was there in the work groups, and I worked with DG Grow on why the entire competition SEP regulation is coming out. It used to mean technical essentiality. Take it off the board, it doesn't work. Take the patent out of the module, it doesn't work. That's changed, and it's been manipulated, and that's the manipulation we're talking about. What we need is clarity in both what FRAND and what a standard essential patent definition means. Now, you're trying to control both.
I have to keep it to brief. We'll continue. Mr. Johnson.